thank you for being here on behalf of the American Constitution Society and the Federalist Society. This is our annual Supreme Court preview, and I hand it over to the professors.
All right, thanks. I'm going to kick us off. I'm Professor Campbell. Some of you may have had me or will have me in constitutional law or constitutional rights. This is going to be an exciting term for the court. There are a lot of big ticket cases, including cases in constitutional law and criminal procedure. I'm going to briefly talk about one of those, the DACA case, and then speak to the gun rights case at a bit more length. The DACA case is going under the name of Department of Homeland Security versus Regents of University of California. It's actually a set of 3 consolidated cases. And the basic issue is whether or not the Trump administration's rescission of the DACA policy was lawful. And the Trump administration actually lost in the lower court in the Ninth Circuit and has now appealed to the Supreme Court. And I'm going to only talk about this case briefly because I think it's a massive loser. I don't think there's any chance that the Supreme Court will end up upholding the Ninth Circuit decision. The basic logic of the Obama administration's DACA policy was that it had, as a matter of executive discretion, the authority to decide who not to deport, and that creating a rough policy that provided very strong guidelines was within its executive discretion. And the problem here is that once the executive changes, the Trump administration, as the executive, has exactly the same discretion to decide what to do with respect to immigration enforcement priorities. And so the argument on the challenger side is that the Trump administration, by relying on the illegality of DACA, has gone outside of its power. And I think this is not going to win for a couple reasons. One is that the administration can and is claiming that it's rescinding just because of the risk of illegality, which of course is a reason why governments change their policies all the time. The other thing is the administration has proposed a series of policy arguments for getting rid of the policy. And again, those are exactly the same sort of deference to executive discretion that we see the Obama administration policy relying on. So I would imagine that this case only is a really big, significant case from the perspective of constitutional law if the court actually decides on the legality of DACA, not the legality of the rescission, but actually goes to hold that the administration had authority because DACA was unconstitutional. So I would imagine that the court doesn't do that. That seems like an unnecessarily political decision. There's a much easier way to get around that. But I'll turn now to the gun rights case. This is a case called New York State Rifle and Pistol Association versus City of New York. The thing that's particularly interesting about this case is that it is the very first case that the court has heard since the District of Columbia versus Heller case in 2008, in which the court is actually considering the scope of the Second Amendment right to keep and bear arms. So you may remember there was a follow-up case in 2010 called McDonald, where the court considered whether the Second Amendment restricts state power. That's what we call incorporation, and the court incorporated the Second Amendment against state governments. But other than that case, the court has not held in any way that the Second Amendment provides a right with respect to personal possession of firearms or carrying or use of firearms outside of the home. That was the holding of the Heller case, and so this is the very first time the court will take up that issue. And it's taking it up in a very weird case. The New York City ordinance was actually rescinded both by New York City and by the state of New York, which passed an intervening statute that makes the enforcement of the old New York City ordinance unlawful. So there's a chance that this case will end up either getting mooted or what we often call DUG, dismissed as improvidently granted. But if the court gets to the merits, we might see for the very first time an articulation of the standards by which the court should evaluate gun rights claims. And I think this is a particularly interesting issue that the court will have to think about at great detail in the years to come, because there are two sort of dominant approaches to considering this question, and both of them have very significant drawbacks. So one way of considering gun rights cases would be to use some sort of balancing, and what we often call a tier of scrutiny analysis in constitutional law. Sometimes the balancing is stacked heavily in favor of the government, rational basis review. Sometimes it's stacked very heavily in favor of the claimant, that's strict scrutiny. Sometimes it's somewhat in between, that's intermediate scrutiny. And the big problem with the balancing test in this context is that the government's interest in these cases is public safety. And guns, it turns out, are very dangerous. And so if public safety is a justification for restricting weapons, you, meaning the government, can do a lot to restrict weapons. The problem with that, of course, is that seems to then oppose the constitutional right itself, which involves the right, to some extent, of possessing and carrying weapons. And so this is a major predominant approach that courts have taken in enforcing other rights, but it poses a really significant problem. The alternative approach that courts often take when trying to figure out the scope of rights is to rely on tradition. So what have legislatures, town councils, and so on done beforehand? What sort of traditions have been established that allow the government to regulate in a certain way, or what sort of traditions allow individuals to compose themselves in a certain way? And here again, we have a major problem, which is the entire Second Amendment framework is brand new. There was no individual right to keep and possess arms prior to 2008, and so it's very strange to rely on tradition as a measure of delineating the scope of that right if all of the traditions themselves were created in an era in which that right, for purposes of constitutional law, did not exist. And so we'll see the court either in this case or in the years to come trying to confront that basic challenge. So that's the end of my summary. I'll turn things over to Kevin.
So my name is Professor Walsh. I teach constitutional law, federal courts, and things related to that. And just a pitch for federal courts, you can see it's really hard to understand a lot of what the Supreme Court does without an understanding of the relationship of the substantive doctrines, like how do you evaluate constitutional claims, apart from the procedural, jurisdictional, standards of review, all that other stuff. And I think the guns case is a really good example of that because the mootness issue is front and center, right? Should they even go ahead? The case that I'd like to talk about is a case called Espinoza versus Montana Department of Revenue. And this is a case involving a Montana program that the Montana legislature created to enable students to have scholarships that they and their families could choose to spend at private schools. And as passed by the legislature, the program allowed you to use your scholarship at pretty much any private school. It had to meet some minimum criteria, but it didn't differentiate between religious private schools and non-religious private schools. So that was the program as passed by the legislature. There was a problem with this, though. The Montana Constitution has a provision that prohibits the use of state funds for sectarian education. And these scholarships, even though they're directed to the schools by the individual choice of parents, it's money that is derived from tax credits that taxpayers had taken. And so Montana Department of Revenue looked at this program that the legislature had done, and they then made rules to administer that program. And they made a revenue rule, so we now have state administrative law trying to implement state constitutional law. And the revenue rule said, you can't use your scholarships at religious schools, okay? Otherwise, it's unconstitutional under the Montana Constitution. So this is America. People were unhappy, and in America, if you're unhappy, you sue. And so Espinoza and a few others sued. Ms. Espinoza is the mother of 2 children, and she wanted to be able to use the scholarship at a religious school. And she said, your revenue rule made to implement the state constitutional provision itself violates the federal constitution. So the federal free exercise clause, as incorporated against the states through the 14th Amendment, has been interpreted by the Supreme Court or applied by the Supreme Court to forbid discrimination on the basis of religion. And so it's always hard to figure out what counts as discrimination. But in this context, if you have a generally available program, so it's generally available, and you then carve out an exception and you say the reason you can't do this is precisely because it's religious, that then triggers a heightened level of scrutiny. Now, it used to be that you would say, well, we satisfy that heightened level of scrutiny. We had to discriminate against the religious schools because the Establishment Clause of the Constitution forbids this type of funding. So, as a matter of federal constitutional law, however, that argument went by the wayside, I don't know, maybe about almost 20 years ago now, a little less, in a case that basically said, when you have the money going, even if it's state money, even if it goes to the religious institution through the individual private choice, that sort of breaks the circuit for purposes of constitutional taint under the Establishment Clause, and there's no Establishment Clause problem with it. So now you have states that have essentially stricter establishment analogs. Now, the Supreme Court has dealt with two other important cases in this area. And the way to think about this doctrinally, I think a helpful way to think about it is sort of how do you resolve this tension between a case called Locke versus Davey from 2004 and a case called Trinity Lutheran from 2017. So I'll briefly tell you about those and then just make a little bit of an observation of where things are likely headed, but who knows. So Trinity Lutheran involved, not Trinity Lutheran, Locke is the one we need to start with. So Locke involved a state scholarship program, sounds really familiar, and Joshua Davey wanted to use his state scholarship to go and study to become a minister. And so he wanted to study pastoral theology. And the state denied him the use of that scholarship. This is America, he sued, and it went all the way to the Supreme Court, and he lost. So Joshua Davey was not allowed to use his scholarship. It was a 7-2 decision, and it was a very unusual one because it said we have this general principle that you can't discriminate on, just because it's religious, and this kind of does violate that. And however, we have a long tradition of not allowing public funding for the study of ministry. Okay, and he wanted to study devotional theology, and that is right, even if it's not forbidden by the Establishment Clause, there's some play in the joints, and they can kind of keep their money from going to that. Locke versus Davey. After Locke, people said, well, what is the size of the whole in this non-discrimination principle? Is it just about the ministry, or is it broader? So courts were split on that. Then they took the Trinity Lutheran case, and that involved a funding essentially to use recycled tires for things, go figure. And this church had a nursery school, and they wanted to redo their playground with the recycled tires. They should have gotten them, but they couldn't because it was a church-run playground. And they sued, and they won. So there was a distinction of Locke versus Davey. Hey, that was about the ministry. And then there was this footnote 3, that basically said, they won here, but this is just about playgrounds and tires and stuff like that. And so don't do too much with this, which is a little weird because, well, it's just weird. And so this case is right at the intersection of those. The court is going to decide whether a state can exclude from a generally available thing, religious schools. This could have been decided in Locke versus Davey 15 years ago. They kind of took that detour. They went off to the side. They don't have that escape in this case. So one other thing that I just mentioned right at the end, I think where we're going in this is probably, given Trinity Lutheran, I'd expect them to say, well, that was playgrounds and now schools. The reason I'm a little uncertain about that, though, is that Locke versus Davey looked like it could have gone that way too, and then they went off in some strange direction. So I'm going to leave myself a little bit of an out. Just one last thing just from being a law student. So Josh Davey lost his case, and instead of going into pastoral theology after he went to college, he went to law school. He graduated from law school, and he is now counsel of record on an amicus brief. He's working in McGuire Woods' Charlotte, North Carolina office, and he's now trying to vindicate sort of his loss and try and get Espinoza to win. And I just think that's pretty awesome. So if you lose, go and sue and win later. That's all from me.
That works. I'll go next. I'm Hank Chambers. I teach a number of things here: criminal law, white-collar crime, voting rights, and employment discrimination. So let's talk a little bit about criminal law for the next couple of moments. In theory, it'll be about 6 or so, but we'll see what happens. There are 3 cases, 2 that I'm going to talk about for very briefly, and 1 that I'm going to talk about super briefly. The first very brief one is Kahler versus Kansas. The question presented in that case is, do the 8th and 14th Amendments permit a state to abolish the insanity defense? So this case involved a fellow who suffered from obsessive-compulsive personality disorder, major depressive disorder, borderline paranoid narcissistic personality tendencies, lots of troubling things. At least that's what he said. So at the end of the day, what he ended up doing was breaking up with his wife. He snapped at one point and shot his wife, 2 daughters, and mother-in-law on Thanksgiving 2009. He had not been invited to dinner. That's not why he snapped, but he had not been invited to dinner, so it wasn't, oh, I'm at the table and I didn't like the gravy. No, he drove over and killed them. He did not shoot his son, who was in the room as well, but apparently he was having a better relationship with the son than with everyone else. Well, Kansas' statute says that it is a defense to a prosecution under any statute that the defendant, as a result of mental disease or defect, lacked the mental state required as an element of the offense charged. Mental disease or defect is not otherwise a defense. So the idea is, if you had the mental capability and you had the mentality to commit the crime, that's enough. You don't get a defense from an insanity perspective. Basic idea is that the insanity defense in the United States has jumped off of a rule we call the Mcnaughton Rule, which essentially says that if you don't know the nature or quality of your act, or in the alternative, if you don't know right from wrong with respect to that act, then you're not guilty. You're not morally blameworthy. Now, if you are found to be not guilty by reason of insanity, you don't just walk the streets. You tend to go to a mental institution in order to get treatment, possibly for decades, possibly for longer than you would have been in jail had you been convicted. Nonetheless, what Kansas decided was, we're not going to say that you're not guilty at that point. You are guilty unless you didn't know the nature of the act. If you just didn't know right from wrong, that's a different story. Or if we didn't think you knew right from wrong, that's a different story. What we're going to do is say, you are guilty, and then we can think about how that may affect your punishment. The question is, well, yeah, but can they do that? Or is denying folks the ability to have an insanity defense a violation of the cruel and unusual punishment clause of the 8th Amendment? Big part of the issue will be, what was the law as of 1791 when the 8th Amendment was adopted? That raises a whole set of other issues. But it's one to watch. I'm out of time on that one. Let's talk about Ramos versus Louisiana, which is also going to be argued, or I should say it's going to be argued on October the 7th, 2019. The first case is also going to be argued October 7th, 2019. Question presented here is whether the 14th Amendment fully incorporates the 6th Amendment guarantee of a unanimous verdict. Now, for those folks who don't realize, there have been a couple of states that have had non-unanimous jury verdict requirements. That is to say, in Louisiana, up until the beginning of this year, you could be convicted of any non-death eligible crime by a 10-2 verdict. Now, what's the problem with that? Well, the problem is that if you have some folks who doubt that the defendant committed the crime, or doubt that the prosecution proved that the defendant committed the crime, then that would seem to be a time where we ought to have additional discussion and maybe figure out whether, in fact, the defendant committed the crime. Instead, if you happen to have 10-2, the defendant loses. You know, you think about some of the great movies out there that could not have been made. 12 Angry Men could not have been made because it would have been 10-2 angry men, and that would have been that. So the question that gets asked here is whether the Sixth Amendment's requirement for unanimous juries in federal trials necessarily also was incorporated into the state's structure for unanimous verdicts, or should it not be? This one is interesting. It sounds like one that's a basic argument, but if you go and take a look at the briefs, you realize that what the defendant says in this case is, not only do we think the Sixth Amendment should have been incorporated, but we think a decision that was decided back in 1972, a case called Apodaca versus Oregon, we think that was wrongly decided. And we think it was wrongly decided at the time, and we think the justice who wrote the controlling opinion was wrong at the time, and has essentially been repudiated since then, even though you wouldn't necessarily know that by looking at the cases. Let's say this is a long shot, and they're going swinging for the fences. They're going to have to overrule, this court's going to have to overrule Apodaca, period, in order for the defense to win in this case. That usually is not the greatest attempt in the world to do, but we'll see how this one goes. You got a lot of heavy hitters on this one. So this one could be pretty doggone interesting to see what the court does with this issue of fairness. Last case, very briefly, Mcnaughton versus Malveaux, coming out of Virginia. That case may draw your attention. It's way too complicated to get into any depth today. So here's the 30-second review. It's the D.C. sniper case, or the D.C. sniper case from about 15 years ago. That's my time, but I'm giving myself another 30 seconds. It's a D.C. sniper case from 15 years ago, 2004. The second of the two D.C. snipers, Lee Boyd Malveaux, was sentenced to life without parole in a Virginia state court. He was under 18 at the time he committed the crime. In 2012, the U.S. Supreme Court decided in Miller versus Alabama that mandatory life without parole for those under 18 at the time of their crimes violates the Eighth Amendment's prohibition on cruel and unusual punishments. So what's the problem? The problem is that case didn't come out until 2012. He was sentenced in 2004. So is that rule retroactive? Well, it turns out the Supreme Court said, yes, that rule's retroactive, but it said it's retroactive with respect to, it said that the rule is retroactive, but then the question became, is that rule retroactive with respect to collateral review? If your eyes are glazing over right now, awesome, because that's about where I'm going to stop. At the end of the day, go back, take a look at the briefs, listen to the oral argument, or wait until, with luck, we have the Virginia Solicitor General come in and talk about the case in a couple weeks. So at the end of the day, just think about that case, have it in the back of your mind, and be ready for questions when it pops up, when we get folks here to talk about it in more detail. Bam!
So, great. Can everyone hear me? Good. So I'm Allison Tate. I teach family law and trust and estates, so you might wonder why I'm here, since none of those cases ever go to the Supreme Court. But I am going to talk to you about the Title VII cases and about the cases that involve sex and gender discrimination. And there are three of them. Oh, yeah, I do.
Okay.
I definitely do.
Keep on going. I'm not going to stop.
I just thought you were going to, police me.
Happy to.
Okay. No, I got it going now. We're good. Just before we start, how many people have taken employment discrimination? Okay, good. All right. Okay, so we'll clarify a few things then. So basically, all three of the cases, two have been consolidated, and then there's a third by itself, and they all have to do with Title VII and whether or not employers can discriminate because of sex. And the question is whether that phrase, because of sex, incorporates sexual orientation and gender presentation, right? There's a lot of controversy about that between the circuits, among the circuits, and so it's now up at the Supreme Court. So I'll give you a little about the facts of the case, and you can kind of see what they're about, and then we'll talk about how Title VII works, and it's also the interpretation of Title VII. So there's two cases that have been consolidated. One is Altitude Express v. Zarda, and the other is Bostock v. Clayton County. The Zarda one comes from New York. There was a man, Don Zarda, who was a skydiving instructor, and he was, his job was to do tandem skydiving. So he went up with people and, together they I've never been skydiving, I don't know. They get on top of each other and they jump out of the plane. And so one of the things that he did sometimes to make especially women feel better because they were in very close contact was say, don't worry, I'm gay. And so he was skydiving with a woman, he told her that. She got done skydiving, she told her boyfriend, the boyfriend complained, and Dawn got fired. So the real lesson is never help anybody. He was trying to be nice, like, don't be nice, just skydive. Anyway, so he's fired, and he files a claim saying that this was discrimination. He was fired because of his sexual orientation, and again, the question will be, is that part of Title VII, right? So that's the first case, and it's been consolidated with this one called Bostock v. Clayton County, which is from Georgia. And there was a man who had worked for over 10 years for the Clayton County's Child Welfare Services. He was a coordinator of guardian ad litems, basically. And he was fired after he had started participating in a gay softball league. It was called Hotlanta Softball. He told people in his softball league that they could volunteer for CASA, to be guardian ad litems. And then after his sexual orientation and sexual preferences became known, he noticed a lot of talk about him and his sexual orientation at work, and there were then all of a sudden accusations that he had mismanaged funds, and he was fired. So same thing, he files a claim, and there's a question of whether or not he was fired because of his sexual orientation and being a member of the Hotlanta Softball League. So those two come together, and they both involved somebody who's alleging that they were fired again because of sexual orientation and how that fits into Title VII. The third case is a separate case because it's a case about gender identity and about a transgender person who's claiming that she was fired because of her gender presentation and gender identity. So it's called Harris Funeral Homes versus the Eeoc and Amy Stevens. And Amy Stevens was an employee at the funeral home for 6 years. When she first started working at the funeral home, she presented and identified as a man. During the course of employment, she began living openly as a woman, and now at this point identifies and presents as a woman. The funeral home fired her. They said that when she started living and presenting as a woman, that she was violating the dress code of the funeral home by coming in dressed as a woman. And she was also violating God's ordinance or vision or something like that. It's counter to the religious beliefs of the funeral home owner. So the question here also relates to Title VII. The question's a little bit different because it's not just sexual orientation. It relates to gender identity and gender presentation, and whether Title VII, whether the same phrase because of sex, right, whether that covers transgender people and whether it covers gender identity. So those are the three cases. Again, the controlling statute is Title VII, and this phrase because of sex. It's also, what is also controlling is one really important case called Price Waterhouse, Hopkins v. Price Waterhouse. And it was a case in 1989? Yep. 1989, and Ann Hopkins was an employee at Price Waterhouse. She was an executive, and she was very competent. She performed her job well. She was not promoted, and she did not receive raise and promotion, and her employers, her supervisors told her the problem was that maybe she should be a little more feminine. Maybe she put on some lipstick, maybe she wore some heels, acted a little more feminine, she would have gotten the promotion, and maybe she should try again the next year, go out and buy some lipstick. I was gonna wear lipstick today and I forgot. So anyway, so that case was a real watershed moment for Title VII and the interpretation of Title VII, because finally Title VII, because of sex, was interpreted to mean gender stereotyping, right? So it's not just you were fired because you were a woman or you were fired because you were a man. You were fired because you didn't adhere to gender stereotypes, right? And so gender stereotyping is now part of Title VII analysis and part of Title VII interpretation. And so what these cases are going to be about, right, is not just Title VII and this phrase because of sex, but also about Price Waterhouse and the interpretation that it brings to Title VII about gender stereotyping, right? So there's kind of there's three arguments that all of the petitioners claiming discrimination are making. One is that Title VII, just plain meaning, actually incorporates, right, actually would provide protection for people on the basis of sexual orientation or transgender identity. Because of sex, they say, actually, if you interpret it in a certain way, because of sex actually does incorporate. It does not limit a court, it does not limit anyone to being just being fired because you're a woman or just because you're a man, right? Because of sex, they were fired. You were fired because of your sex, because you were a man who has a sexual orientation of a certain type. So there's a plain meaning argument about Title VII. There's also this argument about gender stereotyping, right, and Price Waterhouse, and whether or not sexual orientation and transgender are part of gender stereotyping. So that's the other argument, and the idea, right, is that across the board, there are numerous forms of gender stereotyping, right? You know, there's certain forms that we all many of us understand in terms of what we think women should do, what we think men should do, but across the board, there are all sorts of various notions about how people should behave according to genders, who they should sleep with, who they should love, what kind of jobs they should have. All of those things count as gender stereotyping, not just, you know, ladies should wear lipstick when they're accountants. So there's a gender stereotyping argument, which runs through both the Zarda and the Bostock, but also is really important in the Harris Funeral Homes case, right? And then there's an argument also about association, right? The sexual orientation discrimination is associational sex discrimination. So those are the three arguments. Oh, wow, look at that. Policing.
Awesome.
Policing failed. So anyway, that's what's going to happen. All of the parties claiming discrimination were not eager for these cases to go to the court. Not at this time, not with this court. They all in their cert petition said, no, please, like, don't take this case. We don't care that there's a circuit split. It's not the right time. This is not the right case these are not the right facts. So there was an attempt not to have these go to the court. So I think in terms of looking at it from the side of wanting to confirm that Title VII incorporates sexual orientation and gender identity into the meaning, it's not looking good. But we'll see what happens. And before I stop, I'll also just give a little plug for the Law Review Symposium. So the arguments for this are on October 8th, and then the Law Review Symposium about Stonewall at 50 is October 11th, and I can guarantee you there will be much conversation about this case. So I will stop there.
Perfect.
All right.
Questions?
I think they're clapping because we left a little room, plenty of room for questions. So let's hear what you guys want to hear about.
I mean, there are arguments that they're going to try to make. They're going to try to make it narrow. I mean, they sort of kind of looked to how Masterpiece went, right? And it's like the ruling in Masterpiece was very narrow, and they're trying to, the people who are trying to shape the arguments are trying to make it narrow as narrow as possible. I mean, that's, I think, all you can do at this point.
Yeah, let me just add one additional piece to what Professor Tate said about the structure. You will likely hear a lot of folks talk about what congressional intent was when they said that because of sex or engaging in particular behaviors because of sex violates Title VII. You actually have to get over that first before then getting to the argument of whether sexual orientation or gender identity qualifies as because of sex. Because there's not really much question that Congress was not thinking about that issue when they passed Title VII in 1964. But the response is, I don't care what they were thinking about at that time. The question is whether or not sex includes these circumstances and these facts, and whether these facts suggest that the employer indeed discriminated on the basis of sex. So you'll hear the congressional intent argument first, get over top of that, and then start thinking about the question of whether it qualifies, whether these circumstances qualify as discrimination based on sex or because of sex.
So with respect to, I think you said it was the Louisiana case where they have to potentially split.
Yeah.
If the court decides that we
could get wild. It could get wild. You know, one question will be, I suspect some of the stuff that they do in Malveaux, or at least related to the Mathena versus Malveaux case, might have a little something to do with that. That's an open question. You know, if one argues that Apodaca versus Oregon was wrong as of the time it was decided, it's a pretty good argument that says anybody who went in on a 10-2 or 11-1 verdict, you know, ought to be either ought to be released or ought to get a new trial. It's hard to imagine the court saying that, and they won't say it here. That is, they'll just put the rule. They'll just lay the rule down. If they lay it down, they'll lay the rule down and say, "Okay, bring another case to figure out what happens." Is my guess. This one has some real interesting issues. Like I say, since Louisiana now has gone to unanimity with jurors, Oregon is the only state that has non-unanimous jurors, or the possibility of non-unanimous verdicts. So Oregon's alone, and we'll see whether the court just says, "Yeah, Oregon, come on back in the line." But your question is a great one, and your guess is as good as mine. Might even be better.
If I could just jump in with a plug for federal courts. Retroactivity is very, very important, because if you think about it, I mean, it's incredibly arcane on the one hand, but imagine you're sitting in jail pursuant to a jury verdict, and oftentimes it's a black box, but sometimes you can do juror interviews, especially if you have a very serious punishment and you're doing collateral review and you hire investigators and you find out, the retroactivity may be the difference between whether you spend the next several decades in prison, or whether you get out. And so the seemingly arcane question of retroactivity also backs you into questions about what is the nature of law and what is the difference between judicially described or declared or found or made law versus legislated law. Because when the law changes, typically the legislature changes it. Well, it doesn't have so-called retroactive effect, although it can. There's due process limitation. But the general rule for retroactivity now, and it took a while to work this out, but generally you are going to be stuck with the law that was in place when your conviction became final. That's going to be the general rule. So once your time for getting certiorari or getting certiorari, once that's over with, you're pretty much done. And so unless there's a deviation from that general rule, and then we have rules about when you do that. And so what's unusual about Montgomery, about the Malveaux case, is Montgomery versus Louisiana, the case that found the mandatory life imprisonment applied retroactively to cases on collateral review. That was to me an unexpected development and a little bit different from what you normally see. And so my guess would be that you wouldn't have retroactivity, but that is a guess, and I think Professor Chambers and I agree on that. So Fed courts, it'll make your head spin, but in a good way.
You also have a problem of the people who were convicted under the old rule didn't necessarily object to the jury being composed in a 10-2 way, and then there are arguments of waiver that the government can make. And so there are a variety of different ways that the court has minimized the impact of new constitutional rulings, because otherwise it would be a complete mess. Well, that's the big issue. So the gun case is a case about possession of a permit that allows you to have a gun within the home. And then the argument that the plaintiffs are making is that permitting within the home requirement has to come with some ability to carry the weapon outside of the home, to go to a gun range to learn how to fire the weapon, to bring the gun home from the gun shop, to go to your second home so that you then have the ability to enjoy the right to own and possess the weapon for purposes of self-defense within that home. And so it's a very narrow argument. It's not they are not asserting a right to carry a weapon, either concealed or non-concealed, outside the home. But for purposes of public safety, that is far more important. I mean, the police unions, advocates of gun control and so on are going to be far more concerned with what's your ability to carry the weapon outside the home. How far the ruling that they issue, if they get to the merits in this case, will bear on that latter question is entirely dependent on what they say in this case. So it could be that what they say here is, all we're saying is the right extends beyond the home. We're not saying how or why. You've got a right to buy your gun at the gun shop and bring it home, and a right to take it in a locked box to the gun range so that you can learn to use it effectively. By the way, New York law now allows you to do that. And so we'll see if the court ends up going farther than that and articulating a broad framework for evaluating a whole host of secondary issues, adopting a tradition-based standard or articulating the right in a fairly broad way, but then saying that it's subject to intermediate scrutiny or strict scrutiny, something like that, then that would clearly have a much broader implication. But we just don't know yet. This is very much early stage litigation. This is the first time we've seen the court confronting a brand new right in quite a long time.
So it is interesting because you got exactly what I said, but what I said was imprecise because when I say the court, right, I actually was referring just to, I want to say 4 justices, and then there are maybe 2 others who kind of joined. It's sort of, the court is a they, not an it. That's the hard thing for describing these cases. I also left out a lot of complicated procedural history. Footnote 3 represented an unstable compromise for purposes of that case. And Locke versus Davey was an unstable compromise insofar as we are thinking about constitutional adjudication in terms of principles and exceptions to principles and things like that. If we think of it instead as highly fact-based, where maybe which sorts of principles they rely on and to what extent they rely on history and other things. If we think of it more in those terms, you might just think this is case-by-case development, and all they did was put on the brakes. So you might say there's 2 times that they put on the brakes. Why do I think, and what do I think? I think they're going to allow the vouchers. I think they're going to send it back down to Montana. So let me just get into the procedural history just a tiny little bit because this also fed courts. So what happened is they sued, Espinoza sued and won in the trial court. Good, congratulations. Revenue rule set aside, regular legislature program comes back in, you can use your vouchers wherever you want. State appeals to the state Supreme Court. State Supreme Court says, okay, fine. You win, but the remedy is to eliminate the entire program because we would rather, or not we, it's sort of as a matter of severability, it's better that this program not exist under our state constitution as a matter of state law than that it exists with this remedy of allowing you to use it at religious schools in place. That's a little bit weird as a matter of state law because the legislature created it without that restriction. But that is a question of state law. At the same time, and the Supreme Court doesn't generally review questions of state law, just federal law. That's the Fed courts piece. However, right, here you have a plaintiff who is enjoying a state law right that then was vindicated through federal law that then another state entity, in this, the state court came in and took it away again. And they're still subject to federal law. So I don't think that the case will be sort of knocked out on jurisdictional grounds. I think they'll get to the federal law issue. But in terms of what the remedy is, there may be, if the plaintiffs win, there may be another sort of round of litigation down in the state courts on the remedy. So apologize for that being sort of convoluted, but that's the law.
I'd just say there is a huge line drawing problem here, and one thing to note is this line drawing problem is about how far the free exercise clause protects religious actors. The exact same types of line drawing problems existed before the court shifted its establishment clause jurisprudence. So you had a whole slew of cases in the 1980s and 90s that became just completely ridiculous about what the government was or wasn't able to fund without violating the establishment clause. The most ridiculous example being, and I can't remember which way this goes, but globes were in, but atlases were out. I mean, it just became absurd trying to delineate what types, you know, because one is a textbook and the other is like a classroom object or something. And that type of line drawing is something the court is going to be very reluctant to try to repeat, but it's not clear at this point how it's going to go about avoiding it.
Sure, we probably have time for one more question.
So as a matter of establishment clause, everyone agrees, not everyone, but everyone accepts anyhow that there is no establishment clause, federal establishment clause problem here. But Locke versus Davey allows for some play in the joints. That is, you can say, hey, we're going to be more restrictive with respect to funding for religion as a matter of state law, whether constitutional or statutory, than the federal government requires us to do. But when you do that, you run into this free exercise problem that says you're not allowed to treat religion worse because it's religion. And so the question is, what is the scope of that play in the joint? And the other thing I'd mention, just as a matter, we've talked about different ways of thinking about constitutional law, principles, traditions, things like that. These cases present as individual rights cases or as limits on what government can do. Those are two sides of the same coin. But they're also federalism cases, right? Because the question here is what, as a matter of federal constitutional law, ought to be the scope of displacing the state policies that are in place. So every time you have a federal constitutional rule or a federal statutory rule that is inconsistent with the state law, well, that wins under the Supremacy Clause. But as a matter of federalism, you are displacing the state policy. And so there's that thread. I have a feeling, at least for the five more conservative justices, although they're not quite a cohesive block, that the sort of non-discrimination piece of this will triumph over appeals to federalism. But I'd expect, if it's a 5-4 decision and Kagan is in dissent, I expect it will be another amazing Kagan dissent like she did in this Arizona school tuition case. Another thing to watch on this case is there's a kind of split among Kagan and Breyer on the one hand and Sotomayor and Ginsburg on the other hand with how to engage the other five. And that has come out in some religion cases.
Cool.
All right, well, I think we're at time.
Thank you guys for coming. Thank you to our interested in these topics, look out for Federalist Society and American Constitution Society events, and look forward to seeing you guys later this semester.
Thank